privileged to have our labor law expert with us today again, Johannes Mokutedi, to discuss two interesting cases. The first one deals with an employee of the mine that wore high heels to work, and that sort of led to him being fired, if I understand it correctly. And then the second one is an SABC employee who was also dismissed, and there was a dispute about that dismissal. But let's get to that one later. Let's first start with the high heel case. What happened there, Johannes?
Okay. Interesting set of facts, basically it's the sartorial elegance look versus health and safety in a workplace.
Yes.
In this instance, the mine employee who was the human resource coordinator was dismissed because of she was wearing heels at the employer at her workplace. Now, to sum it up briefly, is that Teresa May, who is the respondent in this matter, introduced a policy in 2015 that the employees are not allowed to wear their heels and their slippers or sleepwears, as they identified it.
For security reasons, because they could obviously slip more easily with high heels, etc., and slippers.
Yes, yeah. And that was in 2015, in first of June. And they find this policy to be ambiguous. And in 2017, they changed this policy to read more or less the same, but indicating that heels are not allowed within the Teresa premises and even sleepwear, which I still found also to be very ambiguous. Then the same year in September, one of their directors noted Miss Mfukeng wearing high heels. He indicated this to one of the managers that it is contrary to the policy of the company, and ultimately one of the managers confronted Ms. Mfukeng. Ms. Mfukeng complied, but she complied that this was in any way hindering her to display or to show her feminine side, which to a large extent I agree with her. Now, Ms. Mufukeng complied. Now, but Ms. Mufukeng lobbied for support amongst the female employees. She approached a number of them that the policy was not in line with the trends and with the constitution, and ultimately the director, who firstly noted her, heard about Ms. Mufukeng not being happy, and ultimately Ms. Mufukeng was charged. But interestingly, she was charged for insubordination and insolence, which meant that number one, insolence, it's inciting others to do a crime or an unlawful action, and insubordination because of she failed to comply with the unlawful instructions from the superior.
So she carried on wearing the high heels?
No, not really. It's not clear, but that's what she was charged for.
Yes.
And in October 2017, she was dismissed. She referred the matter to the CCMA Rustenburg, and the CCMA Rustenburg, the matter was heard by one Commissioner Matala, and Matala found that found that the dismissal was fair, and Ms. Mufukeng, not being happy, referred the matter to the Labour Court. Now, the question in the Labour Court, which the court had to answer, was specifically this insubordination or insolence. Now, but the court also had to look at these policies of the mine. And interestingly, the court made some remarks, amongst others, that the court indicated that they find nothing untoward or nothing unsecure or unhealthy about wearing a high heel shoe in their employees in their employers' premises. But maybe to give you a brief background is that it appears from the facts that the employer, after introducing this policy in 2015, conducted a research to back up the policy. Now, after doing this research, that the employer unilaterally decided to implement this policy, which makes the conduct to be unlawful.
Without consulting the
employees first. Now, the judge made a remark that it was unlawful for the employer to expect the employee to have acted not according to instructions or insubordinately, against a policy which was unlawful.
I see.
But you know,
Where was she working? Is that clear? Was she working in an office, or was she working at the mine where it might be dangerous to wear high heels, or is that not clear from the facts?
no, it's not clear from the fact. That is one of the reasons for criticism, that the policy was very vague and ambiguous. It was not indicated where,
Okay.
how.
It sounded like it applied to everywhere.
To everywhere,
So
yes.
it's just maybe ridiculous to apply that to an office as well. Someone who just goes to the office never is at the mine as such.
Yeah, and no, bear in mind that she's a human resource coordinator,
Yes.
and from that, you can assume that she was office bound.
Yes.
And
yes.
I think in such instance, it was extreme for the mine to have introduced such a policy. But she was dismissed in 2017, and only in 2022, June, the matter was said in the labor court because of she was
But
not.
there she won the case. No?
Yeah, she won the case at the labor court. She was reinstated with pay and
For the full period.
for the
Yes.
full period from 2017, and the decision by the commissioner in the CCMA was reviewed and set aside.
The wheels of justice turn slowly, no? But
Yeah.
they do turn. So what do we learn? Because surely an employer can make a policy to cover any safety aspects and enforce that policy. An employee who doesn't keep to that policy obviously is then guilty of insubordination. However, what you're saying is that you must consult with your employees. You can't just unilaterally change your policy and that's it.
Yes, that's correct. Therefore, what we learn from this is that as an employer, when you want to introduce a policy, your policy must not be ambiguous and not be clear. Therefore, it's very important that it must be clear, reasonable in circumstance. And before introducing this policy, you must have you must consult with your employers. Otherwise, it will be tempted to be unilateral and it will be an unfair labor practice. Now, in this regard, the judge took this to be an unfair labor practice and regarded the action of Ms. Mufokeng in lobbying support from the others to be reasonable and to be fair in situations such as maybe going for a strike or something of that sort. And the commissioner went on further to tell that the Constitution and the Labor Relations Act covers such instances.
Okay, yeah, interesting. All right, the second one deals with an SABC case.
Yes.
Where SABC was the employer, and I think it deals with the difference between an employee being absent,
yes,
and an employee deserting his work, repudiating basically his contract of service. And the question is, when can you as an employer dismiss someone in circumstances like that? So yeah, please explain.
Okay. It's very important that when you are faced with circumstance or situation where the employee is not reporting for work for a long period of time for you to conduct investigations. Remember, there's a distinction between an extended absence and desertion. Now, the difference between the two is that in respect of desertion, it is when the employee does not have the intention to come back. And in respect of a long period of absence is the opposite. Now, in this instance is that in the SABC case, the employee was absent for a long period of time. After being for a long period of time, the SABC did a disciplinary inquiry and they dismissed the employee. Now, the employee reported for duty, and when he reported for duty, the dismissal was withdrawn. Then, for whatever reason, the employee was also told orally at that inquiry that please come back to work. And the employee, amongst others, alleged that no, she waited for a letter for her to be reinstated to work, which didn't happen. And he was absent for a long period of time. SABC did send various letters to the employee, and there was no response. And ultimately, the employee was dismissed. And the employee was not happy. He took the matter to the CCMA. And at the CCMA, the SABC argued that they did not dismiss her. They simply deemed her conduct to be desertion and amounting to a repudiation of the contract. Therefore, they simply accepted the repudiation and that amounted to a dismissal. Now, the lesson to be learned in this instance is that when an employee is absent from work, investigate why. Then if maybe you realize that it's either desertion or maybe long absenteeism, advise employers to write letters on the employee, issue out the ultimatum, make sure that he receives the ultimatum. If she's not available, maybe on the address, try to use WhatsApp or any form of communication. Just prove that ultimately he was notified about the situation. And in that situation, such as the SABC, as an employer, you can win where he has deserted, and you simply accept the repudiation.
So in this case, who won the matter?
The SABC.
SABC won that matter. Okay. But yeah, as you often say, even if you might have a very strong case from a labor law point of view, you've got to always follow a certain process to make sure that it's fair, etc. No?
Yeah.
So if there's any doubt that an employer has, rather be safe than sorry.
Yeah.
Follow that process and obviously get legal advice if you're unsure about the process to be followed, so you don't regret your steps later.
Yeah, it's very, very important that the CCMA can found you to be procedurally unfair and award a compensation order against you as the employer. Now, in a case of this instance, it's also important to bear in mind that a long period of absence differ from one fax to another.
Yes.
You know, but in our setup or in our law, there's no clear rule which indicates how long is it.
Depends on the circumstances.
Yeah, it depends on the circumstance. I see that in most cases of the CCMA, they would say 5 days. Therefore, if it's 5 days, I see also in many instances in the mines, they would say that it's 3 days. Therefore, it depends on circumstance, but it's very important that we follow the correct process.
All right. Thank you.
Thank you.